Namaskar. I am your host, Advocate Shaurya Saraswat, and welcome to our first podcast session. In our first podcast session, our guest is Justice Hemant Gupta. He started his law career in 1980, whereby he started practicing in civil law, after which he was elevated to the post of Advocate General, whereby he served as the Advocate General in the state of Punjab, from where he was elevated to the post of High Court Judge, whereby he served as the Justice of Haryana and Punjab High Court, from where he was transferred to Patna High Court and got another elevation and got elevated and served as the Chief Justice of Patna High Court. From Patna High Court, he went to Madhya Pradesh, where also he served as the Chief Justice of Madhya Pradesh High Court, and in 2018 he was elevated to Supreme Court, whereby he served as a judge of Supreme Court of India. Currently, he is serving as the Chairperson of India International Arbitration Centre. We welcome you, sir, for our first podcast session. So greetings of the day. Firstly, we are very honored to have you in this podcast session. So today's podcast session is regarding a very concerning and alarming issue, especially for the people belonging to the legal fraternity. It is regarding arbitration. And I personally think that there can be no better person to give us guidance on this topic regarding arbitration. Before commencing with the session, I personally request you to firstly just tell to our audience what is arbitration, because laymen do not know what is arbitration in general.
Arbitration is a private dispute resolution process where instead of a system, the parties choose their arbitrator. Arbitrator means adjudicator. It's a party's chosen judge who decides the interstate dispute between two consenting parties, which is very different from the court system where the parties have no choice in choosing the judge or the process of conducting the trial. But in arbitration, if it is institutional arbitration, you choose not only the process but also how to go about it, how much time it will take, how much expensive it would be, whereas some advantages are not there in the ad hoc arbitration, where you have no control over the time or fee.
Very rightly said, sir. Sir, with this, my next question is this, that recently we have seen that India is heading towards arbitration. India is becoming a capital for arbitration. So, sir, can you please throw some light on this opinion that will India become a hub for arbitration in the future?
In our country, we have grown with the ad hoc arbitration. There are many institutions which were in existence, but the government of India has taken an initiative while enacting India International Arbitration Centre Act 2019. I was appointed as the first chairperson actually on 23rd of December 2022. The first concrete step by the state is with the establishment of this statutory body. So, with the statutory body in place, we are trying to make a convenient hub of arbitration within the country so that the disputant parties can resolve their disputes within the country rather than to going outside the country.
Sir, as parties in India are looking forward for settling their disputes through arbitration. Earlier, they used to go for the settlement of disputes with the courts because they believe that courts will serve justice. Considering the fact that arbitration is a closed room proceeding which is carried out, can we trust upon the arbitration procedure, and can we trust that arbitration is going to deliver justice?
The worldwide commercial disputes are resolved by arbitration. The credibility of arbitrator, if we have a credible arbitrator, it gives credence to the entire process. But if we don't have a credible arbitrator, the entire system falls to place. In India, we have a sufficient large pool of arbitrators, be it former judges, technocrats, engineers, and all other energy experts or experts in the field who can resolve disputes practically which arise amongst the disputing parties.
Very rightly said, sir. Sir, we have also witnessed that recently the court has also started intervening in the arbitration process. So arbitration process is totally altogether a different process which is taken out outside the court process settlement. But now we have seen that in India, courts are the one who are appointing the arbitrators. Also, once the award is passed, the party has this power to challenge the award before the courts. So, what's your point of view in the process of intervention of courts in the arbitration proceedings?
You see, the arbitration proceedings are the willing action of the two disputing parties. Therefore, the highest credibility is given to the award for the reason that it's a party's chosen arbitrator who decides it. But but whosoever may be appointed, but still there can be some difficulty in announcing the award. There can be human errors, there can be technical errors, there can be unintended errors also. So these errors need some supervision, some control at some level. The court is the only competent authority to figure out whether the award should be interfered with or not. It's commonly said that in section 34, which is the provision for setting aside of an award, the court exercises not the appellate powers but supervisory powers. Supervisory power means that you broadly see whether the award is within the four corners of statute, four corners of the contract, whether the relevant documents have been taken into consideration. The court can't go in the decision making process. Ultimate decision is of the arbitrator, which is more important. In appeal, while exercising appellate jurisdiction, the court takes cognizance of the entire matter as if it is re-hearing the dispute. So there is a difference between appellate jurisdiction and supervisory jurisdiction. The court exercises supervisory jurisdiction and not the appellate jurisdiction. Court can't reappreciate the evidence or other facts. Just a cursory glance whether the arbitrator has complied with the four corners of statute or the contract.
Sir, generally we have seen that arbitration process is completed within the timeline which is given to the arbitrators and the parties, but the enforcement of the award takes time. So basically, which affects the spirit of arbitration, because parties go for arbitration for quick settlement of their disputes. But if the enforcement of the award will going to take time, then the spirit of arbitration destroys in that.
You are right. It is commonly said that the problem of a decree holder, which is in this case would be award holder, starts when the award becomes enforceable. Our processes in court is long. It's one factor which actually deters the parties to resort to arbitration in India. But even if it is foreign seated arbitration, for execution will be against the assets of Indian firms in India. So one has to come to India for enforcement of the award. We have to streamline our execution process. We have to make it summary. I commonly say that the award should be executed in a summary way, as in the income tax act second schedule, which is somewhat summary schedule, summary provision, which provision is even applicable to the recovery of dues by the banks also.
Sir, also recently we have seen that the amendments proposed in the Act, we have seen that government is now primarily focusing upon building institutions for arbitration in order to carry out this process as smoothly as possible. But if compared with the world leading institutions like Singapore International Arbitration Centre and many other institutions, what is the key thing in which Indian institutions are lacking, because of which we are till now we are unable to become a global hub for arbitration?
No, the institutions are good enough, but the problem is the legal framework. The appointment of arbitrators takes long time, then the court intervention is there for extension of time to decide to conclude the arbitration proceedings. Then there is a provision of section 34 which is bound to be there because one intervention would be necessary. Then not only one intervention, we have a multi-tier dispute resolution process. Firstly, the principal civil court decides it, which except in few courts where there is a original jurisdiction, it leads to the first appeal before the high courts, and after the first appeal there is further scope of appeal to the Supreme Court. Multi-tier jurisdiction is actually a deterrent for the parties, and we can't do substantially about the multi-tier jurisdiction because the jurisdiction of the High Court is a constitutional jurisdiction either under Article 226 of the Constitution or under Article 227 of the Constitution, is a part of the basic structure. And then comes the intervention of the Supreme Court under 136, which is primarily discretionary, but still the one level of appeal is provided for, which is actually deters the parties from choosing to come to the India.
Sir, as we have seen that government has proposed a 2024 amendment bill regarding the arbitration. So, and I particularly believe that you would have also seen the proposed amendment bill. Then, can you suggest some points which are being proposed, which are going to bring some drastic changes in the field of arbitration?
One of the most important changes, constitution of appellate arbitration tribunal, that is in-house mechanism given to the institutions. The ad hoc arbitration will be not covered by it. If the parties agree for alternative arbitration appellate tribunal, section 34 will stand excluded. So, the entire chain of litigation which happens under section 34 will come to an end. Of course, there will be still a jurisdiction of the High Court to interfere under either under Article 226 or 227, but the appreciation would be very different from that of a principal civil court, and one important tier would be taken care of.
Sir, just one last question. Sir, if it may be possible, then one major reform which you would like to propose in the Arbitration Act, can you please share your views? What will be that?
The intervention of the court has to be reduced at all levels. The appointment of arbitrator should be given to the institutions if we want to promote institutional arbitration. The ad hoc arbitration has to be the thing of past. We can't continue with ad hoc arbitration for long, as it has its own pitfalls, it has its own complications, and which is probably one factor which deters India to become a hub for international or even for domestic arbitration.
Thank you so much, sir. Thank you so much for sharing your insights on this topic.
Thank you. Welcome.